Welcome to our presentation on the subject Legal Aspects of International Business and Enterprises. The topic of our presentation is Bank of India versus Govindaram Narayan Swadnami and others. This is a group presentation prepared and presented by Krishna Tamang, Sudeep Basnet, Prabhat Khanal and Min Guru. In this presentation, we will be talking about backgrounds and fact in the case of Bank of India versus Govindaram Narayan Swadnami and others. Then we'll discuss about the issue, rule of law related to this issue. Then we'll try to apply rule of law in the case of Bank of India versus Narayan Das, and at the end we'll conclude with the outcome. So let's begin the presentation with the backgrounds. So in this case, the plaintiff was Bank of India, and then defendants were Govindaram Narayan Swadnami and so the Govindarams were residents of Hong Kong. The bank was an Indian corporation and its head office was in Bombay. It had a regional office in Tokyo and a branch office in Osaka, Japan. SJL, which carried on business in Osaka, was managed by Mr. Govindaram's brother Kishan Chand Narayan Swadnami, in short form Mr. Kishit Chand, who lived with his wife near Osaka. So in this case, the Bank of India initiated this suit against Govindaram Narayan Swadnami and his wife, who had acted as a guarantors of a line of credit of 230,000 yen that the Osaka branch of the branch had provided Swadnami Japan Limited, which is also called SJL. So the Kishan Chand owned 60% of SJL and the Govindarams the remaining 40%. SJL had drawn bills of exchange that were supposed to have been paid by corporations in Sri Lanka and Nigeria that were run by other brothers of Mr. Govindaram and Mr. Kishan Chand. So what's the events in this case? When the bills were dishonored, the bank sought payment from Mr. Kishan Chand, only to be told by Mr. Kishan Chand that it should pursue the Hong Kong guarantors, the Govindarams. The bank did not care to sue the Govindarams because sometimes before the bills of exchange had been drawn, the bank had agreed to release the Govindarams as guarantors. After the bank obtained a provisional attachment of Mr. Kishan Chand's property interest in Japan from the Japanese courts, Mr. Kishan Chand went to the bank's head office in Mumbai and offered to bear all legal costs if the bank would pursue its claim against the Govindarams as guarantors and the Sri Lankan and Nigerian corporations as drawees of the bills of exchange. The bank then sued the Govindarams in Hong Kong, their place of residence. The Govindarams in turn brought the Kishan Chands into the proceedings as third parties. So at a trial, the Govindarams argued that the proper law governing the guarantee contract was Japanese law, and that Japanese law excused them from liability because the bank had agreed to release them as guarantors. The bank argued that either Indian or Hong Kong law should apply. So then what is the issue in this case? The major issue between these parties is whether or not Japanese law is the proper law of contract, that is the guarantee. So now what the rule of law says. According to the rule of law, the defendant contends for Japanese law in reliance upon the test of closest and most real connection. The plaintiff, on the other hand, contends otherwise in reliance upon the second of the three stages of sub-rule test propounded thus in Dicey and Morris, the conflict of laws. So three stages or sub-rule test mentioned in Dicey and Morris, the conflict of law. Rule 180 defines what determines the proper law of contract. So according to the rule number 1, when the intention of parties to the contract is expressed in words, expressed intention determines the proper law of contract. Rule number 2, when the intention of parties to the contract is not expressed in words, the inferred intention from terms and nature of the contract plus the general circumstances of the case determines the proper law of contract. And finally, rule number 3 says when the intention of parties to the contract is not expressed in word and cannot be inferred, the system of law with which transaction has closest and most real connections determines the proper law of contract. So how can we apply the rule of law in the case of Bank of India versus Govindarams and others? So Bank of India plaintiff argued that the Indian or Hong Kong law should apply based on the inferred nature of contract. On the other hand, Govindarams defendant argued that Japanese law should be used for the guarantee contract based on the closest and most real connection. Moreover, Japanese law protects them from liability because the Bank of India agreed to release them as guarantor. Now the Hong Kong High Court provided judgment. In the judgment, court agreed with defendant and rejected plaintiff argument. So in this presentation, we will be taking the part of defendant. So in this case, the court finds that no intention as to the proper law can be inferred from the guarantee contract and the surrounding circumstances. Meanwhile, it acknowledged the factors pointing to Japanese law as the system with which the guarantee has its closest and the most real connection. Now the judgment of Hong Kong High Court was based on few of the following points. The first one is the place of economic performance. So place of economic performance is regarded as Japan, where the place of events, place of negotiation, place of operation of SGL Private Limited Company occurred. But in second, the form of guarantee has type reference to yen and the bears $100 yen stamp. Moreover, two of the co-guarantor resides in Japan, including Kissinger, who is the most powerful influencer of Mr. Company SGL Limited because he holds 60% of the shares. So now in the conclusion, Hong Kong High Court concluded that sub rule 3 of Dicey and Morris, the conflict of law rule of 180 can be applied in this case, and based on this rule, court provided the conclusion that Japanese law is the proper law of contract of guarantee, and this law excused Govindarams from liability as a guarantor. So in our part, the defendant, we were taking the part of defendant, and now they got excused from paying the liabilities, and that is the end of our presentation. Thank you very much.